Good morning. I would like to extend a warm welcome to you all and thank you for having joined this webinar, which forms part of the authority's efforts to provide the industry with practical guidance on the new authorization process involving all warranted professionals and individuals who were previously exempt under the CSP Act of 2013. Company service providers are gatekeepers to the financial sector in Malta. With the coming into force of this new regime, the aims of the authority are proportionate and risk-based supervision of CSP, ensuring that authorized CSPs are acting in compliance with the applicable legislative framework in place and ultimately safeguarding the reputation and the future of the financial sector in Malta. Before giving you a quick preview of this morning's programme, I wish to highlight a couple of points. First of all, the MFSA takes security very seriously, and this webinar is being conducted using Microsoft Teams, which follows all the security's best practices. For this live transmission, we are also taking all the necessary precautions and protocols established by the health authorities in view of COVID-19. Secondly, please note that this webinar is being recorded and will be uploaded on the CSP dedicated page on our website. Thirdly, certificates of attendance can only be generated if you have logged into this webinar using your email details and full name. As you can appreciate, no certificates can be issued to individuals logging in anonymously. If you are currently logged in with your credentials because you have not created a Microsoft account yet and wish to receive a certificate of attendance, you may access the document of guidance available on our events page on our website. Questions can be sent to our staff throughout the entire webinar by posting them in the Q&A section. There is a dedicated box on the right-hand top side of the screen where you can post questions. We have a dedicated section within the program to answer the questions that we receive throughout the entire time of this webinar. We will be answering to your questions then. Okay, now on to this morning's program. First, we have Emily Benson, Head Conduct Supervision, who will run us through the CSP reform, Building a Compliance Culture, followed by Angela Tones, who will run through the implementation of the CSP reform. Following Angela, we will have Jessica Ajoons, who will take you through the process. We will break off for a short coffee break, and after the coffee break, we will be answering all the questions that you will be sending throughout this webinar. I now pass on the microphone to Emily Benson, Head Contact Supervision. Thank you.
Thank you, Rowena. Good morning, everyone. Welcome to this webinar. It's titled A Practical Overview on Implementation and the Application Process. And our aim in this webinar is to give you an overview of what you actually need to do to apply. As you know, the reform of the CSP sector means that if you carry on corporate services by way of business at the moment and you don't hold an authorization from us, you will now need one. You need to apply within the next month. And in this webinar, we're going to give you lots of helpful and practical advice on how to apply. So what were the objectives? What are the objectives that we're trying to achieve by this reform? First of all, we are trying to ensure that everyone who is a practitioner in this industry meets a fit and proper standard. This is something that I strongly believe the industry wants as an objective. They want us to make sure that everyone in this industry is fit and proper, and that no bad actors can continue to provide corporate services in Malta. Secondly, the aim of the reform is to ensure that corporate service providers adhere to applicable legal and anti-money laundering requirements on an ongoing basis. This is a standard that has applied to authorised firms to date, and now it will apply to everyone. For some of you, this won't be a big change because you are already subject persons. For others, you will have also to get to grips with the requirements of the FIAU. There is a lot of help out there. Their requirements, like ours, are as proportionate as they can be, and they also have brought in requirements in conjunction with the industry. So hopefully they will also be able to support you getting to grips with your obligations. When we brought together these reforms, we applied a risk-based and a proportionate approach. So the regime does apply to you differently depending on your business model. And we'll be delving into that in a bit more detail in a bit. We have tried to make the obligations of the regime aligned to the risks that we think the particular size or structure of business model will present. The overarching objective of this reform is, along with a lot of other reforms in Malta, about improving our international standing, and that is what we're seeking to achieve. So what does fitness and propriety means? This means that there is a market entry framework now in place for all those who provide corporate services by way of business. And as part of that market entry framework, there is a rigorous screening mechanism for people who are coming now within our authorisation remit. So as part of the application process, there will be some screening conducted in relation to applicants. The market entry framework means that persons who've been providing directorship services under the de minimis threshold, and that warranted professionals in respect of corporate services that they provide only, come within our remit as a regulator. Where to start? So starting to build a stronger compliance culture, it starts from the top. There needs to be a strong and effective governance framework. In a smaller firm, that does not need to be complicated, but it needs to be clear and appropriate to the business. The tone from the top about the importance of a compliance culture needs to be set by the board. So the board of directors has to understand and communicate to its firm what having a strong compliance culture means, what its expectations are. And the board of directors needs to be responsible for ensuring that this culture is embedded across the organisation at all times. Boards are responsible to monitor that what they want in terms of compliance culture is developing, and and to monitor that compliance culture is being observed. What does good look like in a governance structure? Accountability and transparency. As I said, it doesn't need to be complicated, but it needs to be clear who's accountable for what, and roles need to be clear. Policies and procedures need to be tailor-made. This means that they need to be aligned to the business, appropriate to the business, and that they shouldn't be just generic templates. They need to reflect the business that they are intended to apply to. And policies and procedures are one way in which the board can reinforce its expectations of its firm. Reporting lines are another really important criteria, and in relation to reporting lines, the work of the compliance function and the work in relation to anti-money laundering functions needs to be documented, and these functions need to report to the board regularly and appropriately. So if the business model contains some components that are high risk, then the policies and procedures and the reporting needs to reflect that. Likewise, if it's low risk, then the policies can reflect that fact also. Senior management need to oversee the operation of the control structures, and they need to be familiar with and understand the rules. Staff will also need some training, and this webinar will be recorded, for example, and maybe one resource for you. We have approached this in a proportionate and a risk-based way. We have gathered a lot of feedback from the industry in our consultation processes, 2 consultations, and we've had a lot of detailed and insightful feedback. As part of that exercise, this has helped us to clarify the revised rules and regulations and helped us provide specific guidance where the industry has seemed to need it. So one area where I can give as an example of our proportionate approach is that the requirement for an independent risk management function has only been applied to Class C, and that for the smaller CSPs, there is a possibility of a derogation from having an independent, having an external independent risk management function, provided that somebody within the business is responsible for overseeing risk. So we expect that businesses will be aware of what their risks are, but that this doesn't need a full-blown risk management function. Another area where we have flexed our requirements is in relation to capital and insurance. So the capital requirements differ for a Class A under threshold. You'll hear my colleagues talk about the under threshold distinction, to the capital requirements for Class C, which is obviously the biggest and the highest risk category. Likewise, the insurance requirements have been flexed in relation to the under thresholds. In our guidance, we have given guidance on what the by way of business determination is, and it sets out criteria as to how to interpret by way of business. Again, I think we'll be discussing that some more. The test is a factual test. So at the end of the day, you have to, if you're struggling, you have to identify the facts, communicate with us, and we can guide you. In relation to the by way of business, for example, we do look at whether the services are incidental. That means that they are provided in the context of another service, and they're fundamentally ad hoc. They're not provided on an ongoing basis, but they're a one-off. And in that case, as I say, you'll see in the by way of business guidance that there is a flexibility, and that in those situations you won't always have to apply for authorization because it's ad hoc. Putting this all together, what do we hope this will achieve? We hope that this will put our jurisdiction at the forefront of good international practice. There is a clear line of travel internationally in relation to financial services to expect ever higher standards, and we think that we're going to put Malta at the forefront of those high standards. Thank you for your time, and I shall now pass across to Angela to give you further details, and I hope you enjoy the webinar.
Thank you, Emily. Good afternoon, everyone. My presentation is going to deal with the implementation of the CSP reform, and I would like to address some of the main points of this reform on the basis that some of you might have read the CSP Act, but they may still have some doubts whether this applies to them or whether they need to consider whether they are working by way of business or otherwise. So on this basis, I have sought to address the key dates, the key resources that are available online, and also the main changes in the legal reform. So the first key date, the CSP reform came into effect on the 16th of March 2021. I say that because the Company Service Providers Amendment Act came into force on that date. But we must bear in mind that this has been a journey. We have a number of milestones that we need to bear in mind. We started with a consultation about raising the bar for company service providers back in October 2019. We wanted to consult with you as the people who are involved in the company service providers business and who know your clients. After that consultation, we published a feedback statement which set out the MFSA's position on the CSP framework and how this would change. One of those changes was the fact that warranted professionals and people who are currently or who were currently exempt from the de minimis under the de minimis exemption would need to be authorized under the CSP Act. Following that feedback statement, Parliament enacted Act 50 of 2020, being the Company Service Amendment Act, but the Act did not come into force at that stage. In the process of engaging with yourselves, we also published a consultation in December 2020. Under this consultation, which was very focused, we published the draft revised rulebook, and we also asked for your views on specific aspects. For instance, the Class A under threshold revenue, the derogation from the risk management, and the exemptions for specific categories of persons. The feedback was extensive, and following that, we published the feedback statement as well. So the third milestone, in our view, is the 16th March 2021, coming into force of the various acts and regulations. So, as I said earlier, the Amendment Act came into force on that date, but we also have the exemption regulations, which came into force on the 16th March 2021. In addition, we have the fees regulations, which were also published at a later date, but came into force on this critical date, the 16th March 2021. I keep repeating that because it is important that you remember the date, also because of the transitional provisions that are built into the Act. So what happened next? The MFSA published its revised rulebook for company service providers, and that is available on the MFSA website. I will point you in the right direction in the next few slides. In addition to that, the MFSA also published the guidance on the application of the CSP Act. What does this guidance deal with? It deals with the by way of business determination. We published information on what the criteria are, we updated that information, but more importantly, maybe we gave some practical examples. So if you find yourself in a particular situation, by referring to this guidance, you may find that your situation is explained in one of those examples. There's a reference to the incidental services for warranted professionals, but there is also examples about people who are involved in family businesses, employees of companies who also act as directors. So you will find that hopefully of use. Finally, we also published frequently asked questions. There are 49 frequently asked questions in total, and after this webinar, there will be many more, as we plan to increase the number of questions based on the questions we received during this event. So, as I said earlier, we published the feedback statement to the revised rulebook consultation, and that was very recent on the 12th of April, and this sets out the MFSA position and the reasoning why some feedback was accepted, other feedback was not, and why we took some feedback and maybe tweaked it to make it more in line with the MFSA's objectives. Very importantly, we also published the guidelines to the new application process for the CSP regime. My colleague Jessica will be dealing with this later on, so I will leave that in her good hands. Finally, there are various circulars to refer to, and here I wanted to bring to your attention that there are circulars also addressed to licensees under the Trusts and Trustees Act and VFA agents, as these are exempt persons under the exemption regulations. However, they still need to notify the authority if they intend to perform CSP services, and there is a specific circular on that to which I would really like you to refer to, because there is a notification process explained there. So this is the website I referred to earlier. This website has a lot of information. It is being regularly updated, as you can see from previous slides. And over here, you will find a wealth of information for you to read. And I really do encourage you to read, because it is important that you are aware of these changes. So bedtime reading for many of you tonight, I'm afraid. So the next section of the presentation I wanted to deal with is the legal reform. There are three main changes to the legal reform to the CSP Act. The first change I wanted to bring to your attention is something that Emily mentioned a few minutes ago in her own presentation. This is the fact that anyone providing CSP services by way of business to third parties is required to apply for authorization under the CSP Act if they want to continue providing those services. So, warranted professionals are required to apply under the CSP Act because they are providing CSP services. Should they not be providing CSP services, then of course there is no need to apply. Also, those people who are providing services and were previously exempt under the de minimis rule will need to apply under the CSP Act. It is important for these people to realize that it is an obligation at law for them to apply for authorization. When preparing this reform, the CSP Act was drafted in such a way to include transitory provisions, and these transitory provisions have been built into the Act in order to make sure that people can sort of gradually understand the system and get into this frame of mind that they are now going to be regulated. So the second reform I wanted to mention to you is the change from registration to authorization. This will mainly impact those who are already registered as CSPs. Their status has now changed to authorized. And these people who had previously complied with the rule book will now start to take measures in order to comply with the revised CSP rule book, and they have to do so by the 16th September 2021. So this is another key date for registered CSPs who are now considered to be authorized under the Act. Until that date, they are required to comply with the revised rule book on a best efforts basis and to continue complying with the previous version of the rule book. So in your diaries, 16 September 2021 for registered CSPs. The next one that I wanted to mention is the introduction of the three classes of CSPs. We are now looking at three classes of CSPs, Class A, Class B, and Class C. In terms of the consultation we had, the CSP rulebook had set out criteria to be applied when a CSP is deemed to be over threshold or under threshold. So these criteria are in the CSP rulebook. If you are considered to be under threshold or over threshold, please look at the definition section of the CSP rulebook, because there you will find the relevant criteria for these particular thresholds. In order to help you a little bit, I prepared these slides as well, asking who can apply. These slides explain who can apply under Class A under threshold, Class B under threshold, Class A over threshold, Class B over threshold, and Class C. So you will see that I have set out who can apply, the type of service, and also for the under thresholds, the particular threshold that you have to satisfy if you want to be deemed to be under threshold. So in the case of Class A under threshold, the revenue threshold applies. That is explained in the rule book, and I have included a small summary over there. For the Class B under threshold, we also have the same format. So who can apply? Individuals. What kind of service do I have to be providing to be considered Class B under threshold, and what threshold applies. Basically, you cannot have more than 10 involvements. And in this case, I wanted to mention that involvements of a person within the same group of companies shall only count as one single involvement. So if you are a director of a holding company and a director of a subsidiary company and they form part of a group, that would be deemed to be one single involvement. And here I refer you to the definition of group of companies in the CSP rulebook, because that is the definition that applies. For the Class A over threshold, we have individuals and legal persons who can apply. The service to be provided is formation of legal persons and provision of registered office, business correspondence or administrative address and other related services for a company or other legal person. So here we don't have any thresholds because once you are over threshold, there is no threshold to satisfy. Class B over threshold, who can apply? Individuals and legal persons. And the services are acting as director or company secretary of a company or other legal person, or arranging for another person to act as director or secretary of a company or a similar role in another legal person. And finally, with the Class C over threshold, this is the class that allows a CSP to perform any services, whether it's formation, whether it's provision of registered office address, acting as director, arranging as director. So this is the widest class that you can apply for. So we have another key date here, and it's very important that we bear this in mind. There are individuals who are not currently authorized but will wish to continue providing CSP services, and they need to apply for authorization. But then there may be others who may decide that they do not wish to apply for authorization, and they may be providing CSP services now, and they want to understand by when they have to divest themselves of that business. The key date is the 16th of May 2021. People who will not apply will be required to divest themselves of their CSP business by that date. And here I would like to bring to your attention the provisions of the CSP Act, in the sense that anyone who continues to provide the service without authorization and without having applied for authorization under the Act will be deemed to be in breach of the Act and will be subject to an administrative penalty if the authority finds that that person is providing services without authorization. For those of you who will apply, now is the time to act. So those of you who want to apply need to bear in mind the 16th May 2021 as well, because that is the date when the LH portal will close. So you need to be downloading your applications and preparing your PQs, because on that date, the LH portal will close, and we will basically be looking at your applications and processing them. So for the applications, the time frame, we wanted to make sure that the process is as easy as possible and as clear as possible. We wanted this procedure to happen without having to receive original documentation unless strictly necessary. So all the submissions of the applications and the PQs will take place through the LH portal. And over there, you have again a link to a website which is explaining the guidelines for the application process. What do we want from you when you are submitting an application? First of all, we would like you to make sure that the application is completed fully and correctly. If you do this, we will be able to process your application quickly and smoothly. If, on the other hand, we receive incomplete applications or information that is not correct, we will have to go back to you and explain that there is something missing, reject your application, and you will have to resubmit your application afresh. So here I have to emphasize that it is in your interest that you provide full and correct information in the application. So for instance, if you are a legal person who is applying for authorization under the Act, you will need to provide a detailed structure chart. This structure chart must provide the information that is indicated in the application form, and the information in the structure chart should be the same as that stated in the application form. Who has to provide personal questionnaires? So, all individual applicants must submit a personal questionnaire. What we are asking is that you provide a personal questionnaire even though you might already have submitted a personal questionnaire in a different capacity, and this is because of the fitness and propriety test that we need to run in the context of the company service provider application that you will be submitting. If you are outsourcing any functions, for example, you are outsourcing the compliance function or the risk management function, the compliance officer or the independent risk management officer will also need to submit a personal questionnaire. Just as a clarification, for those who are submitting an application as an individual, an entity assessment form does not need to be provided, as that applies only to legal persons who are applying. For legal persons, we have published an FAQ advising who needs to submit a personal questionnaire. These are persons who hold an approved position, such as directors in a company, partners in a partnership, the MLRO, the compliance officer, any senior manager. So please refer to the FAQs if you have doubts whether you fall within this approved position. An entity assessment form will be needed in respect of each applicant. And again, I must emphasize that if you have submitted a personal questionnaire, you will still be required to submit a personal questionnaire in the context of the CSP application. In general, we have made your life as easy as possible. We have moved to everything being submitted digitally, except for a few documents. So in the personal questionnaire, you will note that a few documents need to be submitted in original. For example, an original police conduct certificate and a certified copy of your identification document. Please refer to the website that is embedded in this link. This will lead you to the personal questionnaires page, and it also provides a very useful video that you can follow in order to determine how to complete and submit a personal questionnaire. Moving on. So, as we said earlier, the CSP Act has introduced classes and thresholds for CSPs. How are we going to classify applicants? All those applicants who have submitted a complete application will be classified by the authority. We will be sending a notification in writing to the applicants advising of the classification and threshold. And here my colleague will be delving into more detail. When we have a situation where an applicant potentially disagrees with our classification or threshold allocation, that applicant has 7 working days from the date of receipt of the notification from the MFSA. Within that date, the applicant has to confirm that he is in disagreement with the allocation, and he will be asked to provide further information to support his claim or her claim. In relation to the under thresholds now, I would like to give some more dates that are very relevant. If you are applying for an authorization under the CSP Act and you will be classified as an under threshold, then your authorization application will be either authorized or declined by the 16th November 2021. So the authority will be in contact with you by that date to tell you if you have been accepted as a CSP or whether your application has been declined. You will hear a lot from the authority before that date. We will communicate with you regularly through the messaging portal, and we will also request clarification or information as necessary. So we will be maintaining regular contact with you. The relevance of the 16th November date is obviously that by then you will receive a confirmation one way or the other whether your application has been accepted or declined. For Class Cs and over thresholds, these persons also have the same date to bear in mind, but their process is going to be slightly different. So these people will be either provisionally authorized or declined by 16th November 2021. However, we have to bear in mind that provisional authorization is a temporary concession. Once you have been provisionally authorized, you will be requested to provide possibly more information, but you will be allowed to continue operating as a CSP for a further period of 1 year, up to the 16th of November 2022. By that date, the authority will issue a final determination, advising whether you have been authorized or whether your application is being declined. So, what happens in the meantime? Provisionally authorized CSPs, have they been given sort of a carte blanche just to operate without having to comply? No. Basically, provisionally authorized CSPs have to comply with the provisions of the CSP Act, even though they have only been provisionally authorized, and they have to comply until the 16th of November 2022 or until such time as they received an approved or declined answer from the MFSA, whichever is the earlier. Obviously, if you are authorized under the CSP Act, you will have to continue complying with the provisions of the Act. As mentioned, the provisional authorization is a temporary concession and a privilege which the MFSA is given in order to allow the transitory provisions to take their course. For Class Cs and over thresholds, we are estimating that there will be maybe more complex structures, or the range of services will necessitate further documentation and information to be provided. So that is why we need that extra time until the 16th November 2022 to process your application. You will be able to continue acting until you hear from the MFSA. Regular contact again will be maintained with these applicants, and you will be hearing from us on a regular basis, requesting more information or clarifications, or just keeping you in the loop about the status of your authorization application. Finally, I would like to thank you, but I would also direct you to the CSP reform email, cspframeworkqueries@mfsa.mt. So you can ask any questions that you wish to address, and one of the members of the team will be assisting you. Thank you very much, and I wish you a good afternoon.
So, good afternoon. My name is Jessica Ajus, and today I'm going to take you through the application process. As you can see on your screens, this is how my session will be structured. As a small side note, I would like to let you know that whilst the authority is aware that some of the attendees might already be familiar with these processes to be mentioned today, the focus here is the new applicants. So we are here trying to help the applicants to provide more guidance and as much support as necessary. So by way of introduction, as my colleagues have already mentioned, CSP authorization has now been extended to warranted professionals as well as those persons that were previously acting under the de minimis rule. The framework in place from our end has been supplemented with the rules, with the FAQs, with the guidance notes, the guidelines to the application process, the exemption regulations, and the fees regulations, all being done for the sake of the applicant. We are doing this to help to increase in efficiency, to ensure that there is also ongoing interaction with the applicants. So with all of this in mind, our main scope was to provide as much support as possible to the applicants. So The next step, what is the license holder portal? But before answering this question, perhaps a more important question to ask is, why did the authority select this LH portal? Why are we using the LH portal? Basically, we are using this portal because it is a web-based application. It ensures ongoing communication with the applicants. It is more efficient, and we've made sure that all the information required is in one place. So whatever anything that the applicant might need throughout the application process has all been grouped in one place. So you go to the LH portal and everything you need, from guidance notes, from applications, PQs, everything is there. Now, through the LH portal, candidates for licensing as well as already licensed entities can submit applications, personal questionnaires, any supplementary documentation, upload regulatory returns, so on and so forth. Now, the application process, we will be going through each section one by one. Perhaps the most important question that many of you out there have been asking is, what will be the application fee? So I'm happy to report that the application fee will remain the same, and that is €250. An application fee has to be submitted with each application. So if you are going to submit an application, you need to have settled the application fee. The fee is to be paid electronically, and until and unless a fee is settled, unfortunately, the authority will not be in a position to process the application submitted. The authorization process, what will the authority be doing throughout this authorization process? Well, first of all, the authority will be conducting some preliminary checks and risk rate the applicant. The authority will also be determining the class to be allocated to the applicant, as well as either fully authorizing an applicant or else provisionally authorizing the applicant. And this will happen within the first 6 months following the closing of the LH portal. And as my colleague Angela mentioned, this date will be the 16th of November 2021. Now, the process of provisional authorization here, I would like you to associate the term provisional with the following classes. So you have over threshold class A, over threshold class B, and C. What will happen is that within the first 6 months, as I said already, the applicant will either be fully authorized or will be provisionally authorized. Once the applicant is provisionally authorized, there is another 12-month period of provisional authorization where the authority might request the applicant to fulfill further conditions or submit any further documentation. It is important here to mention that the authority following this 12-month period still has the final say, so to speak, whether to grant or refuse authorization to the applicant. Allocation of class. Okay, so how will the authority communicate this allocated class? We've been mentioning the LH portal. So the allocation of the class will be notified through the LH portal. The decision of the classification of the applicant will rest with the authority. However, the applicant is given the opportunity to either accept or reject the class allocated by the authority. In the case where the applicant has some form of objection and wants to reject this class, reasons have to be provided, and these are to be provided through the messaging system, as you can see on your screens, through the blue envelope on the LH portal, and these have to be done within 7 working days. no, sorry, 7 working days from the notification of the allocated class. Now, here you have a template of what the message ready allocation of class will look like. So, in the red box, you can see that this applicant was given a class B over threshold classification, and the applicant is then requested to either approve or reject the class assignment. This is all done through one click of a button. So you go into the LH portal and you can straight away approve or reject. Next step, the first screenshot provides a view of what the LH portal application log looks like. So the applicant will see whatever was submitted, and if any notifications are received from the authority, these will be visible in this log. So the first logged item, as you can see on your screens, is the notification of the class, whereas the second logged item is a confirmation that the application has in actual fact been submitted. Now, going back to the notification of class, let's say the applicant does not agree with this class, and wants to reject the class allocated. There is that blue envelope on the side. The applicant can press on that, and it will take you to the messaging system as per the screenshot below. Now, there you can see that there is the classification by the authority, and then the applicant can write a message where they are rejecting or approving the classification, and if they are rejecting, giving reasons as to why this class is being in actual fact rejected. Next up, refusal of applications. So, as we've mentioned beforehand, the authority can decide either to authorize the applicant, provisionally authorize the applicant, or refuse the applicant, and this refusal can be done in both phases, okay? So phase 1, within the first 6 months, following the closing of the LH portal, the authority can refuse authorization, but also the authority can refuse authorization of those individuals of those applicants that were given a provisional authorization if the conditions posed were not fulfilled and the information provided was ultimately not deemed satisfactory. How to create an account. Now here you will have a step-by-step guide as to how to create an account. Now you will see that it is very, very easy to do, and this was done with the applicant as well in mind for efficiency purposes more than anything, and to facilitate the process for whoever is applying. Now, before I continue, I want to refer you to the guidelines for the application process. All of the information I am discussing during this session is included in that document, including screenshots and including even further information. So, as soon as you log in through the web address at the bottom of the slide, you will go into the LH portal. Now, you will get the first web page. You can either decide to press on the register button through the login page, or else decide to close the login page and press register through the menu page. This will take you to the same destination ultimately. Again, creating the account is very, very simple because all you have to do is include some basic information. So, for example, an email address and some identity information. So, name, surname, ID card. Those fields are mandatory. And once you create the account, the portal administrator will prompt you with this message. So, new user has been successfully created. password has been sent to the email address provided. So it is important that the email address provided in the first instance is the actual email address that the person setting up the account wants to use throughout the process. What happens at this point is that the portal administrator will send an auto-generated password to the applicant, and at this point, this password will be used for the activation of the account. So, through the activation of the account, and this is again a very simple process, and it will not, for sure, take you more than a minute or two, I can assure you. So, through the first screenshot, the applicant is to press on the account control panel, which will then take you to the login page. You are to use the email address being utilized for the setting up of the account, the password that was auto-generated, and click login. Once you click login, the password will need to be changed, so you will no longer be using the auto-generated password, but you will create your own password. So you will insert the current password, a new password, and then confirm this password. Change password, and that's it, you're done. Now, the application. So this is perhaps the most important part of this session, so please make sure you listen up to everything that is coming up. Completion of the application. If you send a completed application, the process is going to be smooth. There will be no issues. If anything, it will be time effective because the authority will have all the information it needs and no back and forth in this respect will be required. Whereas if, on the other hand, the application provided is incomplete, unfortunately, the authority will need to ask further questions, probe further, and there will be this back and forth between the authority and the applicant, which will, lengthen the process more than necessary. So, and this also applies to the submission of the PQs and the supplementary documentation that go with it as well. So it is very important at this point, it is essential that the application provided is completed in its entirety. Next step, so selection of application forms. Once you go to this page, the application that you are required to complete is the one at the bottom, the last one. And here I want to explain a little bit more about this application because we've had questions like, why? But why did you create a separate application? Why go through the process of setting up a new application? Well, this was done for a reason. Reason being, first of all, that previously applicants had two applications. So one was for individuals and one was for corporate entities. Now, more information has been included in the application and there is only one application. All information has been incorporated into one application, making for less requirements because everything is in the application now. And again, I'm going to continue harping on the efficiency of the process. Everything was done with the intention of making things quicker and easier for the applicant. Now, another very important point is that this application needs to be completed in the cases where the applicant already has an existing CSP business and falls within the scope of this new CSP regime. So, if you fall within the new CSP regime, this is the application you need to complete. Whereas on the other hand, and here we need to create a distinction between the two, if you are a new applicant and you do not have an existing CSP business, in that case, another application would need to be completed. And this application, we call it the standard application. This application can be found on our website, and I can tell you exactly where it is. So it is on the MFSA website, firms, conduct supervision, CSPs, and then you will find a section entitled Regulation. When you click in that section, you will find the application that would need to be completed in this respect. Okay, this is again a very important step. So here, the first step is to identify whether the applicant is an individual, a corporate entity, or a civil partnership. The second section, section B, includes a link to the application, so that is where you can download the application from. This application can also be found on the dedicated CSP regime webpage that can also be found on our website. And the next step is the PQs. So that link included there is to further information and guidance in relation to the completion of the PQ, but the PQ can be found as well on the LH portal in the menu that is on the left-hand side. Now, in section C, you can add any additional documentation that you want to add to support your application and the PQs. And if, however, you go into the LH portal, now you will find that this page has slightly changed. And why has it slightly changed? The reason is that about a week ago, we were having discussions as to how we can facilitate the application process a little bit more, perhaps. And we thought of here adding another section between sections C and D. And we've added a payment section. This payment section includes the bank details for 2 bank accounts of the authority. It includes also the payment reference that needs to be included, that is CSP Reg dash the name of the applicant, and also includes a reminder that the settlement of a fee needs to be done with every submission of an application. Having said that, then you have section D, which is the consent section, where you are declaring that all the information provided is correct. Once that item is ticked, you press submit and the process is done. Signatures. Okay, so signatures on the application. Here, it is important, as you can see on your screens, this is the final declaration page of the application. It is important here that the applicant reads and understands sections A to E included in this declaration page. And if these sections are agreed upon, the applicant can then go ahead and sign the application. So in this declaration section, if the applicant is an individual, of course, the application is to be signed by the individual. But if the applicant is a legal person or a partnership, in that case, it would need to be signed by 2 legally authorized persons to represent the applicant. Now, instead of asking the applicant to provide the whole application in original to make matters a little bit easier, once again, we wanted to ask the applicants to send only the final section in original of this application, so this declaration page, signed in original and sent to the authority within 2 weeks from the electronic submission of the application. I repeat, 2 weeks. Submission of the relevant PQs. Now, with the application, there needs to be the submission of PQs as well, as we've already mentioned. And as you can see, there are 2 phases, and the PQs are being submitted. We are adopting a staggered approach in this regard. Why is this? This is because we thought of the applicant, the load on the applicant. So basically what we wanted to do is to facilitate the process a little bit further and select a few PQs to be submitted in the first phase and then a few other PQs to be submitted in the next phase. As you can see here on your screens, there is a small table that will show you the PQs that need to be submitted in phase 1 and phase 2. So, if the applicant is a legal person or a partnership, the PQs to be submitted in phase 1 are for the directors, the MLRO, and the compliance officer. Whereas in phase 2, the PQs that would need to be submitted are for the ultimate beneficial owners, the risk management officer, and this is only applicable in the case of Class C, senior management, and committee members where applicable. In the case of individuals, you will see here that there is only one phase to this process. That is because we aim to provide authorization or otherwise in the first phase here. In this case, the PQ needs to be submitted for this individual. If the risk management function in the case of Class C and the compliance function are being outsourced, a PQ will obviously be required in these cases. It is important here to mention that if the applicant is an individual, the MLRO function cannot be outsourced. Now, supporting documentation required. Here you have a list of the documents required to be submitted with the application as supporting documents. And here you will see that these need to be submitted by not later than the 15th July 2021. And here the authority has been thinking of the applicant once again, and we've been giving an extra 2-month period for the applicant to provide the said documentation. From discussions with stakeholders, we've noted that this consolidation of business has become a very popular feature amongst potential applicants. So what we did in these instances, since it seemed to be very popular, we thought of putting some new procedures in place where the applicant can be guided as to what needs to be done and what needs to be submitted, essentially. So here I will be going through briefly the process, which is twofold as well, for consolidation of businesses. Once again, all this information and further more detailed information can be found on the guidelines to the application process document that is on the webpage of the CSP regime. So, as I said, consolidation of businesses can happen where there is a business that wants to consolidate its business with another business, or else where businesses want to consolidate and create a separate legal entity. The first step here is to submit a transitory application. This transitory application is the application that you can find on the LH portal, as I've mentioned earlier on. And the reason why this needs to be completed is because it is essential for the business to continue to operate during this period. If an application is not submitted, the business is expected to cease all its CSP activities and contact the authority accordingly. In the transitory application, the information to be included needs to be for the persons that are currently providing CSP business. Whereas on the other hand, the second application, that is the standard application form, as I mentioned before as well, needs to include the new CSP services that will be offered through this entity, and also the new individuals that will be included within this business. PQs. So with the transitory application, the PQs that need to be submitted in the case where the CSP business is operating through an individual is the PQ of this actual individual, whereas for legal persons, the PQs that need to be submitted are for the directors, the MLRO, and the compliance officer. Submission of PQs with the new legal entity application. So here you have a list of all the PQs that would need to be submitted with the second standard application, let's call it like that. Once this application is granted an in-principle approval, the PQs that were submitted initially with the transitory application will be grandfathered to the new legal entity. So here, once again, this was done with the applicant in mind because we want to avoid duplication of information, duplication of work. So in this manner, we will use the PQs and transfer them to the new standard application, standard business, making for a more efficient process as well. Once this legal entity is fully authorized, all the business can then be transferred to this entity and the transitory application will at that point be withdrawn. Okay, so that's it from my end. I want to encourage you to have a look at the page on our website dedicated to the new CSP regime, the guidelines to the application process, and if you have any questions, we will be happy to answer your queries through the CSP Framework Queries email address. Thank you. Now, I'm going to pass you on to my colleague, Romina.
Thank you, Jessica, for that overview and for all the screen grabs that you provided. May I please remind you that you will be receiving the presentation following completion of a short survey that you will be receiving via email later this afternoon after the end of this webinar. Following completion of your feedback of the survey, you will be able to access the presentation, which will have all the links that my colleagues have mentioned. We will now be taking a 10 minutes break. We will be back in the session at around 20 past. We will do our best to address the questions you have submitted during the Q&A session. Please feel free to submit all your questions in the Q&A section found on the right hand of this webinar screen. Thank you very much.